Welcome to the Ottawa Business Journal's live broadcast of ESA Developments, What Employers Need to Know. I'm Michael Curran from the Ottawa Business Journal. Thank you for joining us today. One of the big challenges of being an employer is keeping up to date with changes in the law, whether it's legislation or new legal precedents. Something we keep hearing from our legal experts is how missing small details can cost employers dearly. And that's why our audience appreciates the insights that we are sharing with our partners from Emond Harnden LLP through these live broadcasts. By the way, I just wanted to pause here for a second. I was checking this out last night. There are a dozen of these videos that we've done now with Emond Harnden. So it's a treasure trove of information. If you want to find them, by the way, just Google OBJ YouTube or Ottawa Business Journal YouTube. There's an entire playlist called Employment Law with Emond Harnden that you can check out. Again, a dozen great videos. In today's show, we're talking about the Employment Standards Act, which we'll be calling ESA for short. This is a law in Ontario that protects workers' rights. The ESA has many of the rules that employers might follow. Some examples might be minimum wage, overtime, setting up public holidays, work hours. So you might be thinking, well, isn't that just straightforward? It's commonplace stuff. The answer is no. Since the pandemic, and beforehand, ESA changes have been making news headlines. So this has been a big topic of discussion, particularly for the people watching our live broadcasts, people that are owning or managing businesses or HR professionals. So today is all about giving you an overview and an update on these changes. OPJ's partner employment law broadcast is Emond Harnden LLP. This is a local law firm that was founded in 1987. Since that time has steadily grown to have the largest group of lawyers focused on labor and employment law in the National Capital Region. One of the things that's really cool about Emond Harnden, it's a boutique style law firm that specializes specifically in this type of law and also specializes on management side. So you're always getting as business owners and managers, you're always getting that perspective, which is fantastic. Today, we're thrilled to welcome Associate Veronica Blanco Sanchez to give us the latest updates about the Working for Workers Act. Here is Veronica. Hey, Veronica.
Hi, Michael. How are you?
Great. These are such useful conversations. I keep telling your colleagues, Veronica at Emond Harnden, that whenever we start marketing these and put the registration, people flock to these seminars. So it just continues to demonstrate to me how important these issues are. And today, I guess we're talking about the Working for Workers Act. And as I said a second ago, it seems like this has been in the headlines for 2 or 3 years since the pandemic. Is that true from your perspective?
Well, that's exactly it. Particularly since the pandemic, the government has done a very active effort to continue to develop the ESA, and we're on our 5th Working for Workers Act. So yeah, it's ever changing. So I'm glad that you're hosting us to, try to stay a little bit ahead and try to be as proactive as possible in letting our clients or all employers really know about these changes that are very constant.
That's exactly it. That's exactly, and it's a perfect segue. So we're going to give our viewers now a little bit of a preview of what we're dealing with here in about the next 30 minutes. So our first topic is to take a look at the changes in this act that are already in force. So that's the key point of that graphic: the changes in force. The second one are the changes that are awaiting proclamation. And in our third topic, we're looking at Working for Workers 5 Act. Changes not yet passed. As is always the case in these live broadcasts, we want to take your questions. So regardless of whether you're on YouTube or LinkedIn or any other social media platform, you can use the comment function on your platform and we'll get them in our virtual studio here. So we're going to encourage you to ask some questions. Around 12:25, we'll be back with you. But let's get down to business here, Veronica. So we're going to go to our first topic as planned, which is the Working for Workers Act for 2024, and we're going to look at the changes that are now in force. Over to you, Veronica.
Thanks, Michael. So some may be aware, but not all, because of it's so constantly changing. So in March of this year, Ontario did pass Bill 149. So you can refer, I hear references to both Bill 149, Working for Workers 4 Act. They're the same. So it has been passed, and now some of the provisions are enforced, though not all. So I'll just start with as you mentioned, the ones that are enforced. These are aimed mostly at restaurant, hospitality, and service workers, but they do apply generally. They are part of the ESA as a whole. So there are four primary provisions that are already enforced that employers should be aware about. And the first one is trial periods. Second is withholding, deducting, or return of wages. Third speaks to direct deposits and tips. And the last one is with respect to vacation pay. So I'll just break those four down a little bit. Looking at the first one being the trial periods. Under the ESA, the definition of an employee includes a person who receives training from a person who is an employer if the skill in which that person is being trained is a skill used by the employer's employees. I know that's a lot of words, but it essentially is if the skill is used by the employer, then that constitutes training. However, there was a little bit of a I don't want to say confusion or misunderstanding when it came to trial periods. So if you're testing someone out, perhaps that's not training. This is looking to get rid of that. There is a trial period in which this person is not quite, um, you know, uh, uh, formerly not on payroll, but not officially being trained just yet. There were shifts essentially that employees or workers were not being paid for. This is now out of the question. This is clearing up that confusion, and anyone that does perform any work during a trial period must be paid. So that is the first primary change that is already enforced. The second one, it has to do with withholding, deducting, and requiring the return of wages. This is mostly what we would be known as dine and dash or gas and dash. Formerly, some employers could withhold wages from, say, servers or workers working at the service restaurant industry and gas stations. That when, we all know, the dine and dash or gas and dash, those workers would be essentially lose out on the equivalent of the loss. That is no longer permissible. The ESA and this bill, or now act, specifically gets rid of that. Employers cannot be withholding any of lost wages that result from any goods, services, etc., that the employer loses out as a result of a customer or a client. When moving to the third one, and this gets a little bit more nuanced here, it speaks to direct deposits and tips and gratuities. So what Bill 149 did, it added a requirement that employers must pay tips or other gratuities by cash, check, direct deposit, or any other method essentially that regulation prescribes. Those regulations have not been implemented yet, so we don't know if there are any other ways. However, these are the most common, of course. What Bill 149 did is that these payments, if they are by cash or check, they must be given to the employee at the workplace or another place that the employee has agreed to receive such cash or check. Additionally, it also amends, so Bill 149 amended when direct deposits may be used for wages, and those same requirements now also apply to tips or other gratuities. So direct deposit may only be used for wages and tips if the account to which it should be direct deposited is selected by the employee and is in the employee's names. No other person than the employee or a person authorized by the employee has access to the account. And lastly, that the account meet any prescribed criteria. Again, those regulations are not yet there are no regulations to that effect, so there currently is that there is no other prescribed criteria. Now, the difference here, and again, this is why I said it gets a little bit more nuanced, is because previously the criteria for wages to be paid by direct deposit was only that the account was in the employee's name and no other person than the employer or a person authorized had access to it. Now, so those smaller details is that the account is specifically selected by the employee, and again, just keeping an eye out on regulations to see if there's any other prescribed criteria. In with respect also to tips and gratuities, Bill 149 also addresses employers who have a policy that allows the employer or a director and shareholder to share in tips or gratuities. So this is when we know about pooling tips and redistributing those. In those circumstances, the employer now must post the policy in a place where it is likely to come to all employees' attention. So not only must that policy now be posted physically in the workplace, but the employer must also retain that policy for 3 years after it ceases to be in effect. So not 3 years from when it became instituted or for when it became or it was posted, but 3 years from when it stops being in effect. So that is the third change that speaks directly to tips and gratuities. Now, the last change that is already in force, brought by Bill 149, speaks to vacation pay. Again, a little bit more of a nuanced change. So this is the ESA currently states that an employer must pay vacation pay in a lump sum before the employee commences their vacation. However, it also allows an employer to pay vacation pay accrued during a pay period if the employee agrees. Okay. And when other requirements are met, such as if it's less than 4 weeks, for example, of vacation taken. But now, so even though it was not before you could pay at a time that it was agreed to by the employee, this is now explicitly adding a requirement that it must be an agreement in writing. This isn't just kind of speaking informally. It's not about an oral or an informal agreement or agreed to. Now it is where the previous wording was a time agreed to by the employee, the new language now allows payment at a time that is set out in an agreement that the employee has made with the employer, and the definitions, detail that to be an agreement in writing. So those are all of the changes that are already in force. Again, some general, some a little bit nuanced, and I know it sounds a little bit, nitpicky, but that's exactly what these changes are trying to address: is to be precise, so that employers are aware, as are employees, of what it is that some of these relationships are supposed to be carried out.
I find a lot of these quite fascinating. So, I mean, the first thing that occurred to me, Veronica, is that this was a sector during the pandemic that was really hit, right? And it was not only the
Absolutely.
restaurant owners, to use that as an example, that were suffering, but it was the workers. And I think there's a lot more empathy, maybe is the right word, for some of these things. So some of these policies changes, legal changes. So when I think, example, that the tip gratuity thing here, I mean, this is something that a lot of people talk about. That's been in the news too, about people are being encouraged to provide tips to service workers,
Right.
but a little bit of uncertainty as consumers. Who's getting them, and I know that falls outside the purview of this broadcast a little bit, but I think everyone would agree it's a great thing to have transparency about. If I tip my service provider, where's the money going?
That's exactly it. I mean, yes, even though it's outside the purview and we're talking kind of in very specific, ESA, this is something that we see every day that is talked about in kind of everyday aspects of society. And this is, having that transparency for everyone that knows about tips, which is, all of us, is it's really great to have that clarity. And that way, there's no confusion or misunderstandings in terms of how these are supposed to be paid or what it is that is supposed to occur.
Yeah. It's all, I don't expect the general populace to kind of applaud employment law changes, but this this is one that might get broad-based support. So listen, we're going to move on to topic two, but just to acknowledge, by the way, that we had a little technical glitch for our first 2 minutes. And if you're watching, use the comment functions. We have someone answering questions in terms of links and comments and all that type of thing. And to assure everyone, all of these are available, as I said, in replay. So please stick with us live here, and we've got lots of fantastic more information coming up. But you can continue asking your questions via comments, whether that's a technical thing, but also let's remember we're doing a Q&A here in about 15 minutes or so, or maybe about 10 minutes. So, all right, Veronica, let's go to our second topic. This is the Working for Workers for Act 2024. So we talked about changes that are in effect. These are changes awaiting proclamation. So once again, take it away, Veronica.
Precisely. So this is all stemming from the same bill, still Bill 149, still Working for Workers for Act. But as you mentioned, it's a bit of a split in terms of when the different provisions come into force. So while these have been passed, they're not yet enforced. In other words, they don't yet apply until the government decides or sets a date. And these are focused on publicly advertised job postings. I have seen a lot of buzz about this. I wrote an article for the OBJ a few months ago, kind of in anticipation. So now we're seeing it, take a little bit of more momentum. Now it is officially passed. So what we will see here is employers will have to post the expected compensation or compensation range in a publicly advertised job posting. So what these are, there's different components to this here, but one aspect of it is that publicly advertised job posting and compensation range may be defined at a later time by regulation, but we don't have those details yet, which is probably why it's not into force. Obviously, this will not be $1,000 to $100,000 range. That's it's trying to promote that transparency, but we will get a little bit more guidance from that in the regulations, presumably once this comes into force. So that is the first expected change. It will occur. The second one is that employers will be prohibited from including any requirement that relates to Canadian experience. Now, one thing to note here is that Canadian experience is an area that has been addressed by the Ontario Human Rights Commission as being a requirement that could raise human rights concerns. For example, one of the grounds under the Human Rights Code is place of origin and ethnicity. So kind of that Canadian experience, the government seemed to see it as a bit of a workaround in terms of seeing, who might not necessarily target, but be incidentally fall under those grounds. So that cannot explicitly not be mentioned or required in a publicly advertised job posting. And that's the second incoming change. The third one relates to artificial intelligence. Again, another very popular, very buzzing topic right now. But this one is that if an employer uses AI, artificial intelligence, to screen, assess, or select applicants, then the employer will have to include a statement disclosing that use. Now, again, what artificial intelligence means has yet to be defined. We are expecting that it will be defined by regulation, but that has not yet been detailed. For now, we do know that an explicit statement will have to be included in those publicly advertised job postings. Now, there is a possible exception to some of these requirements, but again, these are to be outlined by regulation. Now, in terms of those are, I would say, probably the most buzzy topics, but there are still a couple of more changes that is important to recognize about the incoming changes. One being that as an employer will be required to retain copies of publicly advertised job postings and any associated application form for 3 years after access to the posting by the general public is removed. Okay, so no matter how long when you put up the posting, but after it is removed and any associated applications, you must retain those copies for 3 years. Now, lastly, the last change that will be coming is no, sorry, that is the last change, but I do want to note again that a lot of these will depend a little bit on what the regulations state or define when it comes to these changes. So it's important to stay tuned in that regard, particularly because we do know that this will be implemented. This is it's already passed.
Yeah, I imagine it's a little bit of devil in the details type stuff on this. It's fascinating, just topics like such so real world, right? About
Mhm.
the compensation range, for example, Canadian experience, use of AI. I'm sure many organizations are trying to use AI to siphon through applications and create some efficiencies there. So yeah, this is just really interesting stuff. We're going to move to our third topic. A reminder again, we're going to the Q&A. I've already got some questions on my mind, Veronica, but I'll hold them in my head so we can start. Topic number 3. This is the Working for Workers 5 Act. So now we're looking at, I believe, future legislation and something that isn't yet passed. But tell us more, Veronica.
That's exactly it. This is still in the bill format, which means that, as said, it has not yet passed. It is currently at second reading, and it was referred to the Standing Committee on Finance and Economic Affairs in May, so quite recently. So while they are not, this bill is not enforced just yet, it's important that employers stay aware of them and keep an eye on the progress of the bill, because as we have seen with other Working for Workers acts, they tend to pass. There might be some small adjustments, but these are things that are very much on the radar of future implementation. So there's three primary components here that employers should be aware about. So it's more information and more details on publicly advertised job postings. Employers would be required to include a statement that discloses whether or not the position that's being advertised is for an existing vacancy. The provisions of this act, and which by the way is Bill 190, also allow for other information to be included, but again, as may be required by regulation. And additionally, when employers would be required to provide applicants who are interviewed with prescribed information within a prescribed time period. Now, I know we hear the word prescribed used a lot. That does mean that it's things that regulation will detail. It's not things that are quite in the act or the bill just yet. But this is essentially saying that job applicants, candidates will be entitled to and those that have been interviewed specifically will be entitled to certain information within a certain amount of time. So we'll have to wait and see what that might mean, but it is an added right for job applicants and candidates. Now, additionally, Bill 90 does provide the manner in which this information is provided to applicants. Again, things to be added by regulation, but the fact that it's in the bill, it does speak to what will be required. Just the manner, the method, the timing, those details are to be decided at a later time. And with that, on that same spirit, employers would be required to retain copies of information that is given to an interviewed applicant for a period of 3 years after the information is provided to the applicant. So again, definition of what it means to be interviewed, and the information that applicants and candidates may be entitled to will be detailed at a later time. But again, just must be I would encourage employers to kind of just stay a little bit on top of this, because I mean, as you know, we're conducting recruitment, I'm sure, is ongoing on a daily basis. So that will be a key change. Now, a second key change here is evidence for sick leave. Now, I will um, uh, detail that this, when I speak to sick leave, I mean the ESA prescribed sick leave, meaning the 3 unpaid sick days. So currently, under the ESA, employers can require an employee who takes sick leave to provide evidence that is reasonable in the circumstances that the employee is entitled to that leave. However, if Bill 190 were to pass, employers would still be able to require evidence that's reasonable in the circumstances. However, a certificate from a qualified health practitioner, meaning what we all know to be its doctor's notes, will not be something that can be used as such evidence. So it will no longer be as simple as as requesting a doctor's notes. That will not count as evidence that is reasonable in the circumstances. Now, the Ontario government has indicated that another form of evidence can still, could be an attestation for example, from the employee, but this will heavily depend on future ministry guidance to be developed and see what comes out of what may be sufficient or what may be reasonable in the circumstances. The key here is that doctor's notes will not. And when I say doctor's notes, I don't necessarily just mean a family physician. This can include physician, registered nurse, psychologist, and actually the bill does say any other professional that's prescribed. Again, that will be detailed by regulation. So that's the second primary it's not expected, but potential change. And the last one, which is significant as well, is that currently the maximum fine for an individual who's guilty of an offense under the ESA and is convicted is a $50,000 fine. However, if Bill 190 passes, that increase would be increased to a $100,000 fine. So while it's not a provision under Bill 190, employers should also note that on May 6th, actually, of this year, the Interior government filed a regulation that increases the penalty for the third or subsequent contravention of the same provision of the ESA within a 3-year period from $1,000 to $5,000. This applies to situations where notice of contravention affects more than one employee, and the fine is required to be multiplied by the number of employees affected. So we can really see an effort by the government to divert any level of contravention from employers. So those are the 3 potential changes. Again, second reading. So it's important to stay tuned because these are, I would consider these to be, significant to not only everyday practice, but the potential consequences of not keeping up with these changes.
You can say that again. This is serious stuff. And we're going to shift in, by the way, to our Q&A session. So I encourage, again, all of our live viewers to send us some comments. I go to you, William, here in just a second with but maybe let me kick this off. And I'm trying to zoom out a little bit of this. Like, I'm almost of two minds, Veronica. Like, some of this stuff just seems like common sense, like making your tipping policy obvious, retaining job postings, AI. The flip side, though, if I'm putting myself in the minds of maybe the people watching this, is there is like an admin burden to all of this. And so any sense of that? Like, it seems, and I hope I'm not asking you for a personal opinion, we're looking for your legal opinion, but it seems like, on one side, these are like, yes, of course we should have our tipping policy. And of course we should, maybe rethink Canadian experience and retaining job posting. But the flip side of this, Veronica, is it's just more paperwork and regulations for, the people watching this live broadcast. Any sense of that, Veronica?
Oh, absolutely. No, this is definitely, you will need to rely on your admin and HR professionals quite heavily on kind of the instituting these and keeping up with these, because it certainly is on the heavy on the administrative front. And it's a big requirement, especially when it comes to these retention components as well, right? You have to be aware of where those 3 years post, there's a lot of kind of timelines to
For
keep up
sure.
with, right? So yes, it will certainly require leaning on our support, on our admin support to help us implement these changes.
Okay. And I'm going to come back to ask you about penalties, but before I do so, I want to give a chance here to some of the viewers. So William is asking, do these potential regulations actually reflect an improvement when compared to existing rules, I guess? So again, it kind of touches on my question, but are you seeing these as an improvement? And let's put you guys are always so great at Emond Harnden and wearing your employer hat on. Let's take it from that perspective, because I'm sure the employees would say, of course, all of these are an improvement. Yes, all of this should be done. But from an employer point of view, do you think this is an improvement?
I think it is. I mean, obviously, we can't forget that the ESA is certainly a legislation that's there to protect employees.
Yes.
However, I think that these changes are being used to also provide clarity and transparency to the employers as well, so that if there is any confusion or allegation from an employee, now there's a bit more of a clarity in these various topics that we have touched on today. So yes, no, I understand, and especially when these vary, there's some kind of minute components to it, but that is trying to get rid of those
Yeah.
uncertainties. Like the vacation pay one is like, oh, now it has to be in writing. Where if you kind of read the compare and
Mhm.
contrast the language, it sounds you can barely tell the difference. But in practice, I mean, it's at least providing that clarity that employers can absolutely kind of rely on to equally eliminate any uncertainty that an employee might be alleging.
Absolutely. And just to comment on, my first take was from an admin perspective, but I picked up on something you said, Veronica, which is if we all aspire to be great employers, then of course these are some and being a great employer means we've got great relationships and great engagement with our employees. Then if you take that higher level view, I get what you're saying, more regulations, but hey, here's a question that might be difficult to answer, but Margarita's asking when it pertains to the salary range. So let's say there's a
Mhm.
job posting and it says we need to have a salary range. Is there any sense of like how big that could be? Obviously, it's not going to say like $1 to $1 million.
Right. No, that's exactly. I mean, this certainly the spirit of implementing this change is transparency, right? And while I don't have a sense as to what it might be, I mean, I can speculate that it can be, a 10% range. I can speculate
Sure.
within, a 5 to 10K range. I can't be sure, but I would expect it to be on the smaller rather than larger side, because if it's on the larger side, then that kind of defeats the purpose
Yes.
and objective of implementing
Yeah.
the change. It might also vary by level. I mean, for example, the ESA has different requirements or obligations depending on, for example, executive or exceptions for executives versus non-executive workers. We might see some differentials there, but yeah, we really just have to wait for that regulation to come in to see just how far into the details it goes.
Good
But
point.
I'm hopeful it'll be directive. It will be a proper directive.
Yeah. I'm going to put this one up on screen too. I don't think you can answer it or anyone can answer it, but because it pertains to AI, you raised it. So I'll just flash it on screen here. And it might just be let's all think of this together. But it says, if using AI for screening applicants, such as Indeed, are these companies required to keep results for the amount of time not sure employer has access? So again, I don't expect you to answer that. It's just fascinating to think that as employers were using job posting platforms, those job posting
Mhm.
platforms, that might be where the AI screening is happening. So, how is, me, Mike Curran, that runs Ottawa Business Journal, going to
Yeah.
understand completely what AI was used to screen,
Well,
screen applicants?
and that's what it would, and yeah, of course, I don't necessarily have an answer
No,
to that.
no.
However, I will say that that's where it will be important to look at we are expecting a definition of AI
Yes.
when it comes to the regulation, right? So I'm
Yeah.
not sure. Yeah, when it comes to using third party service providers, I think that, one step removed, the obligation is on the employer itself. Employer is defined in the ESA. So, while there might be,
Yeah.
I'm not sure if there's any other external obligations, but kind of keeping those things in mind. I'm hopeful that again the regulations can
Yeah.
provide some when it comes to the definition of AI specifically.
Yeah. There's always some ambiguity, right, when it
Yes.
comes to
Oh,
AI.
and of publicly advertised jobs. So that will also
Yes.
be defined what it means to be a publicly advertised job. Yes.
Great. That's a great point too. Listen, we'll start wrapping up, but I want to give Jody Gervais a shout out here. And again, I don't know if it's a question, it's a question you can answer specifically, but I just like putting some of them up because it gets all of us here together. We've got a few hundred people watching. When it says we have to keep an application for 3 years, does that mean a generic copy of the form used or the forms completed by candidates? Again, that might just be an answer, Veronica, where it's like, let's wait to see the nitty gritty of the regulations, but any quick take on that?
I would say I mean, I always err on the side of being a conservative interpreter in terms of protecting the employer as much as possible. I read it to be the actual filled out application form because
Okay.
right now it says any associated application form.
Okay.
So when it says associated to the job posting, I mean, I would be cautious in that. Again, keeping in mind that this is an a legislation that tends to be, provide clarity not for employers, for usually for the benefit and protection of
Cool.
employees. I would suspect is for the keeping application forms that were submitted
Okay.
through the publicly advertised job posting.
And that makes a lot of sense. So listen, we're into overtime a little bit here, so we're going to shift into our key takeaways section. So we always do this, at the end of these live broadcasts, so everyone can kind of wrap their minds around what was said and focus, especially if you're, an HR practitioner or business owner here, Veronica. So we'll bring up our key takeaways slide, and you can walk us through these.
Yeah, no, absolutely. So, I mean, as we talked about today, there were three primary components, right? We talked about two different acts, one of which is all has been passed. That's Bill 149. So that, which is the fourth Working for Workers Act. And we talked about two components to that, right? With the changes that are already in force. And those are, as a reminder, paid trial periods, not withholding or requiring return of wages when it comes to, for example, dining and dashing or gas and dash, but that applies to really any service that would require the return of wages for any monies lost. The third change already in force is a requirement on payments of tips and gratuities. That's specific to the use of direct deposit and the accounts there, as well as a requirement to post a policy in a place that all employees can see it, and the retention period on that policy as well. And lastly, the clarification about vacation pay agreements and payment of vacation pay. The key there being that it must be, rather than the former, which was having to pay a lump sum of vacation pay prior to a worker taking that vacation, you now have to have a written agreement with the employee that says, you can pay it, for example, in your regular payroll schedule, right, or when the vacation was actually accrued. Now, those are the primary provisions that are now in force. The second takeaway here is keeping in mind the incoming changes. Again, things that have passed, they are happening. Those will focus on the publicly advertised job posting and a lot of buzz again on the compensation range, AI, no mention of or expectation of Canadian experience. And those are still dependent a little bit on what regulation will say in ministry guidance. And then lastly, the last takeaway here is that there's a fifth Working for Workers Act. So yes, Bill 149 has passed. Now we're looking already to the next one. And again, while it has not passed, there are some, potential changes, big ones here that employers should keep an eye on over the next coming months as the bill works through. And those, again, more details and requirements about publicly advertised job postings, specifically on AI, and the prohibition of doctor's notes. Again, expected hopefully some guidance on that, and the increased maximum fines for contravening the ESA. So these are just, those are the key takeaways that I hope that you all take from today, because I know there's a lot to keep up with, but we're trying to break it down and be as proactive as possible.
There are some good ones, some good takeaways there. And this is the time where we really, really emphasize, Veronica, that, kudos to everyone for tuning into this. Kudos, for staying in touch with Emond Harnden. But if you're going to make any decisions on these things, be sure to talk to a lawyer. Sorry about that. Be sure to talk to a lawyer is what I was saying. So we're going to bring up your contact slide here, Veronica, because again, and just emphasize that getting some general information like we did today is good. But listen, everyone's in a different context, right? Could be public sector,
Absolutely.
private sector, union, non-union. Veronica, you need to
Oh
talk to
yes.
someone.
Oh yes.
And of course, the what we're saying here is, if you want to talk to someone, talk to Veronica. So, listen, Veronica, it's been a great show. All of these are just so real world, helping all of us employers try to sort out what we should be doing from a rules perspective, from a legislative perspective. So, I want to thank you for bringing all this expertise to our live broadcast. Thanks so much for your time today, and we look to continue working with you and your colleagues at Emond Harnden to provide these great resource.
Absolutely. Thank you so much, Michael. I really appreciate the opportunity. Again, I'm hoping to help employers just kind of stay ahead of the curve in these things. So I really appreciate you putting this on. It's been a pleasure.
Yeah, it's great. All right. There's Veronica Blanco Sanchez. Thanks to her for making this time today, and to all of our colleagues at Emond Harnden. Listen, we're going to sign off from OBJ, but a couple reminders. One, we say, and by the way, you get employment information. We do report on HR type issues. So you can go to obj.ca. That's our website. It's updated every day throughout the day. Lots of new content. I also recommend, by the way, that people subscribe to our email newsletter. Our main email newsletter is called OBJ Today. It goes out Monday to Friday, typically sent around 4 o'clock in the afternoon. I know I fully get that no one's looking for more emails in their inbox. This is a good one because it kind of summarizes the day. You can look at it for 10 seconds and then archive it, or if something tweaks your interest, you can click on it and dig in a little bit more. Of course, please follow us on social media. For those of you watching this on YouTube, click the like and follow. The red icon, if you hit that one to subscribe, then when we're live on YouTube, as we are today, you'll get a notification. So that's all the time we have for today. On behalf of my colleagues at Ottawa Business Journal and our friends at Emond Harnden, thank you for watching. Please stay tuned for more information to come. Thanks for joining. Bye-bye.